We'd like to welcome everyone to today's webinar. Our topic today is Mid-Year Bankruptcy Outlook, Legislation, Enforcement, and More. I'm Blake Hogan, CEO of AIS Law and AIS. We're so thrilled to have such a large group join us today. Hosting today's webinar will be John McMickle and Cliff White. John is co-founder of North-South Government Strategies, a Washington, D.C. based consulting firm. He served as counsel to the Senate Judiciary Committee, where he advised Chairman Grassley on an array of policy matters under the committee's jurisdiction, including the last comprehensive rewrite of the nation's bankruptcy laws. Joining John will be Cliff White, who I'm excited to introduce as our new Managing Director of Bankruptcy Compliance here at AIS. Cliff assists clients in effectively administering their portfolios of default loans and implementing systems that meet the highest standards of excellence and legal compliance. For 17 years, he led the United States Trustee Program. He is the recipient of 2 presidential rank awards, the highest recognition accorded to senior career executives by President George W. Bush and President Barack Obama. As director of the U.S. Trustee Program, his accomplishments included the implementation of key provisions of the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005 and the Small Business Reorganization Act of 2019. We have a large number of attendees on the webinar, so we have elected to keep everyone on mute in an effort to enhance the listening experience. However, this is meant to be interactive, so you can share your questions by clicking on the Q&A feature or chat function at the bottom of your screen. We'll do our best to address as many questions as possible at the end of the discussion. This is being recorded, so a link will be distributed after the webinar, along with a copy of the slides. With that, I'll go ahead and turn it over to John and Cliff.
Thank you very much, Blake. And like Blake, I'm super excited to be joined by Cliff White here. I believe he's the main attraction. So if we could go to the next slide, I'm going to provide a little bit of a legislative political update as it affects kind of the bankruptcy world, and then turn it over to Cliff, who can provide a lot more color and detail about the way regulators and enforcers in the new administration may be looking at the bankruptcy space. So most of the time, if any of you guys have been on prior webinars that I've done for AIS, I've talked a lot about, well, something might happen. Something actually did happen. So the SUBCHAPTER 5 debt extension. You may recall right before COVID, Congress created a new sort of fast track process for small businesses to use Chapter 11. In the CARES Act, one of the first COVID relief packages, the amount of debt that a business could have was increased to $7.5 million on a temporary basis. That temporary increase has lapsed. However, Congress passed a statute that would retroactively increase, go back to the 7.5 figure for the next 2 years. Of note, this legislation originally was going to make the change permanent, but many creditor stakeholders, really the banking sector being the primary group, objected to permanency on the grounds that the statute was too new to make permanent, and we needed more information about whether or not this particular fast track process could be abused in some ways. So this new legislation is passed the House, passed the Senate, was presented to the president for signature on June the 9th. By my math, he has until the end of this week to sign the bill or it gets vetoed. There is no expectation at all that he won't sign the bill. I think it's just not been sort of put to the top of the stack of papers that I'm sure is on his desk. So, you know, we can keep you posted, but whenever he does sign it, probably the end of this week, we will have to talk about this again in 2 years at a future AIS webinar. Can we go to the next slide, please? Okay, so there are some other notable provisions in the same piece of legislation that may be even more directly relevant to listeners than the SUBCHAPTER 5, which is really kind of a business issue. The legislation increased the debt limit for Chapter 13 to $2,750,000, which is a pretty substantial increase over current law. In addition, the legislation also does away with the sort of current, soon to be non-existent distinction between secured and unsecured debt. I think the net result of all this from a legal and business operational point of view is that you may start to see increased Chapter 13 cases with much higher debt loads. It's a little hard to figure out right now whether that means you're going to see customers in Chapter 13 with bigger mortgages or customers in Chapter 13 with bigger unsecured credit card type debt. We just don't know. This provision too will also expire in 2 years. So we can have a future discussion about that. It will be, and I think AIS can be deeply helpful in this. It'll be curious to watch how this particular provision expands itself, plays itself out over time, looking particularly for situations that that people might consider to be an inappropriate use of consumer bankruptcy. So that's actually happened, which is a long way of saying I'm going to talk about some legislation, if we can go to the next slide, which is pending. I don't know that we're going to see a lot of action on these upcoming bills, so I'll kind of go through them real quickly. Congress, if you've paid attention to the news at all, has got much bigger sort of issues on the table, bigger fish to fry. So these are issues that we may see come up in the end of the year, sort of like after September, October timeframe. So there's a bill that would increase, that potentially would increase proof of claim filing fees. This actually passed the House of Representatives in the last Congress. It's been reintroduced in the Senate. The Senate Judiciary Committee has already passed the bill, but the full Senate hasn't taken it up yet. The original draft of the bill directed the federal courts to increase a proof of claim fee. The bill's been modified somewhat to give the courts broad discretion to increase fees in general, but the expectation is they're going to use that broad discretion to specifically increase proof of claim filing fees. Any of you are on the call who work for banks or have clients that are, sort of like large volume POC filers, this could have a meaningful impact on your sort of cost of business. So if we could go to the next slide, please. This is another bill that, again, if you've been on prior AIS webinars, student loan debt forgiveness is continuing to languish in the Senate Judiciary Committee. There are bankruptcy and non-bankruptcy provisions. The bankruptcy provisions would allow discharge of federally backed and federally made student loans. So it really doesn't affect private student loans. That in and of itself so far has not become controversial. The legislation considers, it contains provisions that relate not to bankruptcy at all, but to clawbacks and student lending rules that have held the bill up. I think the fact that this bill has languished in the committee just has not taken it up, even though the chairman of the committee really believes this is a high priority, very much increases the likelihood the Biden administration is going to use some kind of executive power to do some kind of student loan debt relief or forgiveness. The expectation in DC is that something will happen probably late summer, early fall, because the administration wants to time it to, so the closer we get to the midterm elections, where Democrats are expected not to do well. I don't know if any of you have paid attention to it, but the controversy around the Biden proposals that have been floated really has generated a discussion about the fairness of forgiving, student loans for people that, whether or not that's fair to people who didn't go to college, people who did go to college but paid off their loans. I bring that up because that debate about whether debt forgiveness, debt relief, debt discharge is fair to other people has really been missing from the bankruptcy debate in the political sense since around the 2005 era. I just flagged that for you because I wonder whether or not we're going to see kind of an increased focus on the fairness to everybody else kind of argument when it comes to debt forgiveness and debt discharge, generally not just bankruptcy, but in other categories. So if we go to the next slide, please. So at this point, as I said, it's the outlook is for a lot of being stuck in place for the next few months until the late fall, and then some minor things can happen. However, just understand that in prior situations where the president's agenda is stymied on Capitol Hill, Well, what happens is the administration starts trying to do things using its existing inherent executive authority. And for this, I want to turn it over to Cliff White, who's sort of been there and done that and knows how this works in great detail, and let him just kind of give you the view of a very recent federal enforcer and regulator. Cliff?
All right, thank you, John, and good afternoon to everyone. It is indeed a pleasure to be with you in this seminar for the first time as a member of the AIS team. So let me tell you just a little bit about myself beyond Blake's kind introduction. I retired at the end of March of this year after 42 years of federal service, with the overwhelming majority of that time at the Department of Justice. And after several years in headquarters operation and in a field office, I then served for 17 years as head of the department's United States Trustee Program. And as director of the USTP, I managed about 1,000 lawyers, accountants, and support staff in Washington, D.C., and in 90 field offices. So I guess you could say I had the privilege of being both a bureaucrat and a lawyer, which I am sure is every banker's two favorite things. Now, as many of you know, the USTP is what Congress called in the legislative history the watchdog of the bankruptcy system. The program carries out administrative, regulatory, and enforcement responsibilities to be sure that every stakeholder in the bankruptcy system plays by the rules, and not just in the Chapter 7 and 13 cases, but also in Chapter 11 reorganizations, ranging from sole proprietorships to international corporations. Among the major initiatives on my watch in the consumer area were retooling program operations to implement the sweeping bankruptcy code amendments of 2005, designing and carrying out strategies to address widespread mortgage servicer violations, and cracking down on attorney and other professional misconduct. All told, the remediation to consumer debtors alone far exceeded $1 billion. And we did these things under 7 attorneys general of both political parties. So with my professional life devoted to enforcement in related areas, when I retired, I didn't want to switch sides. I had seen AIS in the bankruptcy space for several years and thought of AIS as a problem solver, whether it was helping to identify populations of bank customers to be remediated or improving bankruptcy processes within institutions. AIS was helping create a win-win. AIS was helping clients comply with the bankruptcy rules. And over these past few weeks since I've been on board, AIS has also shown me how they've achieved these objectives cost effectively. And as a government official, the cost part was not my primary concern, but the compliance part surely was. Well, that's more than you want to know about me. Next slide, please. Slide number 8. The next 2 slides are charts showing bankruptcy filing trends. Let me mention just a few highlights. As this first chart demonstrates, bankruptcy filings have been on a roller coaster for the past 20 years. And I can tell you from research and from my own experience as a bankruptcy professional, filings gyrated even before that. Filings exploded from a few 100,000 40 years ago to well over 1 million by the year 2000 when this chart begins. Now you'll notice a peak on this chart of more than 2 million filings in 2005. That peak was somewhat artificial because Congress passed those major bankruptcy reforms in 2005, and the consumer bar thought those changes would make filing bankruptcy harder. So consumer lawyers rushed to file bankruptcy petitions to beat the effective date of the new law. Understandably, that led to a big drop the next year because a lot of debtors filed sooner than they otherwise might have done. Then, as you'll see, filings began to rise back to more expected levels. And moving farther to the right on the chart, as national economic conditions worsened and we entered a recession, filings went up again fairly steeply in 2008 to 2010. Then filings receded as economic conditions stabilized, and filing rates really changed very little from about 2016 to 2019. Then COVID hit in 2020. Now, I was among the very many who expected filings to rise, but they, of course, did not. Instead, they dropped by a lot. Now, in retrospect, this isn't surprising because government cash and other assistance was pumped into the economy, and there were moratoria against evictions. But now there are reasons to believe the trends may be changing. General economic factors suggest that filings may increase, among other things. First, government assistance programs, both cash payments and the eviction moratoria and others, have expired. The gap in time between the expiration of government help and the financial impact that will have on consumers will eventually close. Next, macroeconomic conditions are deteriorating. For the first time since the late 1970s, we're facing high inflation, rising interest rates, and possibly slowing or even negative growth. As you've probably read, the World Bank has warned about stagflation, and Jamie Dimon has said there is a hurricane on the horizon. Unsurprisingly, consumer borrower delinquencies have ticked up. Now, I have no doubt that your forecasting and risk analysis offices already know far more about all of this than I could ever hope. Next slide, slide number 9. Here we see a chart on Chapter 13 filings. This chart shows more recent monthly changes in Chapter 13 filings. It's interesting to note that Chapter 13s began to uptick as soon as government eviction moratoria expired last summer. So we marked that with a big red circle. And as you know, a lot of 13s are filed by debtors who are trying to save their homes, so the eviction moratoria mattered a great deal. So what's the bottom line? Chapter 13 filings for the first 5 months of calendar year 2022 are 28% higher than they were during the same period last year. That's also highlighted in red on this chart. This is significant and may be a sign to get ready for a higher filing environment. Next slide, please. Slide number 10. The last time we saw a poor economy driving up bankruptcy filing rates, government regulators kicked into high gear, beginning under President Bush and then under President Obama. You know that because your institutions were under greater scrutiny. And I know that because I was there when the earliest interagency meetings of regulators were convened in DOJ to discuss the mortgage meltdown. The cast of relevant actors has dramatically changed over the past 18 months. This includes the bankruptcy watchdog and others who affect bankruptcy practices. In government, some of the major players are in DOJ. One will be my successor in the U.S. trustee program. Also, my former boss, the current Associate Attorney General, Vanita Gupta. The Consumer Financial Protection Board Director, Rohit Chopra, is a new appointee of this administration. The Federal Trade Commission now has Chair Lena Khan, and the Federal Reserve has a nominee as Vice Chair for Supervision, Michael Barr, and there are other players as well. If you saw the recent Wall Street Journal profiles of the CFPB's Chopra and the FTC's Chair Khan, then you already know that they have laid down markers across the board about transforming their agencies into more robust advocates for consumers versus business. Outside groups have also weighed in. For example, the American Bankruptcy Institute Commission on Consumer Bankruptcy, on which I served as an ex officio non-voting member, in 2019 made recommendations for changing consumer practice that are now much discussed, and interest groups are mobilized. Bankruptcy is part of a regulatory agenda, but with so many possible initiatives, it's hard to know exactly where in the list bankruptcy may rank, but it's there. If you don't see an uptick in bankruptcy oversight, it may well be because the agenda is packed with other items that will take up resources. To mention just 3 aspects of a bankruptcy regulatory initiative. First, the watchdog could become plural. In addition to the USTP, the CFPB or potentially even other players could more actively insert themselves into the bankruptcy process. By fiat, the CFPB could go into court on behalf of debtors. If not, there will be efforts to be aggressive in taking actions in favor of consumer debtors more generally. Aspect number 2, access to justice. Access to justice is a very popular phrase in this administration. The concept is one all of us probably agree with. Remove unnecessary barriers that prevent the financially destitute from getting their fresh start. Beyond that, the objective of many access to justice advocates is to increase bankruptcy filings by reducing debtor costs and obligations. So here are just some of the examples among the access to justice steps being advocated by consumer groups right now. reduce financial disclosures by debtors because the paperwork burden may be a roadblock to legitimate filings, promote mortgage mediation to resolve disagreements between the debtor and lender over what is owed and whether there should be a mortgage modification, and the Attorney General has already expressed support for mediation efforts. Eliminate steps in the bankruptcy process that may make it harder for debtors to pursue bankruptcy, such as current requirements for taking a credit counseling course or cooperating on random audits. And the Consumer Bar also wants to reduce the number of small asset cases by changing the U.S. Trustees Program standard for meaningful distribution, so trustees will liquidate fewer assets for distribution to creditors. Finally, a third aspect, ratchet up creditor enforcement in areas previously emphasized, such as auditing more proofs of claim for both accuracy and documentation. This would be both in the secured and unsecured areas. Relatedly, to review motions for relief from stay and other creditor actions. And also, as John suggested earlier, according to Director Chopra, scrutinizing student loan servicers is clearly at the top of the CFPB's enforcement list. Next, I want to mention an important Supreme Court case. Just 2 weeks ago, the Supreme Court decided the case of Siegel against Fitzgerald. The case involved the collection of quarterly fees charged to Chapter 11 debtors. And for only the second time in history, the High Court overturned a bankruptcy law on grounds that it violated the constitutional requirement that bankruptcy laws be uniform. In this case, the lack of uniformity grows out of the failure of the courts in 6 districts to collect the fee. The USTP collected the fee properly in the other 88 districts, but it lacked jurisdiction in 2 states comprising 6 judicial districts, which instead use bankruptcy administrators to perform the functions carried out by the USTP and the other 48 states and all the territories. This exception for the 2 states was a political compromise made almost 40 years ago. The court's action in this case on fees calls into question whether there's a lack of uniformity in not having the U.S. trustee program in 2 states, which are Alabama and North Carolina. There's little question that the USTP, as part of the Department of Justice, is very unlike the bankruptcy court administrators. The USTP is independent of the courts, follows consistent policies nationwide, and is more enforcement oriented. If the BAs are merged into the USTP, then you can expect greater oversight and enforcement in Alabama and North Carolina. Next slide, please. Slide number 11. Well, now that we've described a stricter future regulatory environment, the question is how to avoid getting caught up in the regulatory snares. The following suggestions are based on my experience in taking bankruptcy court actions against creditors. If you follow these tips, you'll increase the government's trust in you and make the government more likely to reach consensual resolution. Obviously, you should consult your legal counsel whenever an enforcement matter arises. But point 1, file accurate, true, and complete documents in bankruptcy court. This is self-evident. That generally involves automation so that post-bankruptcy accounts are accurate and comply with the bankruptcy rules. Number 2, when you automate, do it with oversight. In my experience, it seemed that lenders improperly billed customers or filed inaccurate proofs of claim or other court documents because their computer systems didn't reflect the bankruptcy rules. Instead, after the customer filed bankruptcy, the lender process was more manually driven. Pre and post bankruptcy accounting systems need to be automated and talk to each other. And even the best systems need human oversight. Of course, all this is a lot easier said than done. In government, I had no idea how this could be done, but I did know that the lender had no option but to get it right. Number 3, self-report errors and remediate. No matter the violation, it's better to tell the government you messed up a bankruptcy filing than for the government to tell you. That may make the difference between facing a court-filed pleading seeking sanctions versus resolving the matter consensually with a letter agreement. In self-reporting, identify all of the affected populations. For example, is it just HELOCs or all mortgage loans in bankruptcy? Do not undercount. And if you have a problem, remediate it. Let me suggest that if you do rough justice instead of incurring the additional administrative cost of calculating the amount of the error for each individual account holder, the total amount remediated may be greater than the amount that would be paid, because the rough justice remediation will be set on a formula that takes into account the high side of the range of harms that you calculate. Finally, what are the consequences of systemic errors and violations? Under bankruptcy law, lenders not only must remediate, but also may be subject to injunctive relief or penalties for abuse of process. In fact, on June 3rd, as part of a discovery dispute, the bankruptcy court in the Southern District of New York entered a default judgment against Credit One and said it will impose a fine of up to $1,000 per bankruptcy account at issue in the case. If the judge moves forward as intended, the penalty would likely be in the millions and possibly far, far in excess of $100 million. Besides monetary relief, you also may see the rise of independent monitors once again. Importantly, the use of monitors was reduced dramatically during the Trump administration, but monitors are back in vogue in other law enforcement areas now. So do not be surprised to see regulators seek monitors as part of a settlement package. As you may know, monitors are appointed to confirm payments to affected populations, but also to review and certify new automation and business process systems to avoid a recurrence of the systemic errors and violations. Some have told me that monitors can be helpful. Others view them as intrusive. Well, as a wrap up, with the decrease in filings, there's been a decrease in enforcement actions. So this is a good time to evaluate your systems and make sure they're ready for any future enforcement initiatives from the bankruptcy watchdog, the USTP, and also other regulators who have oversight of your organization. So if you think it's time for a regulatory checkup, now may be a good time to do that. Hope the session has been valuable to you, and I would be happy to answer and to learn from your questions and comments. Thanks so much for your time this afternoon.
John and Cliff, thank you so much for taking us through all the material. And now I think, Brian, you might be facilitating some of the questions.
We do have a couple. Do you believe that automation and evidence of transition will head off potential enforcement, or is it necessary to assure past practices were sound?
John, and you can.
I guess I'm not quite sure I fully understand all the question, but I can say that there was a recent situation where AIS assisted a lender that had discovered some errors in its bankruptcy process. And I think the ability of that lender to show that they had brought in automation to fix the system going forward was absolutely crucial to a reasonable resolution to that particular case. I don't think I understand the second part of the question, though, or Cliff, maybe you
yeah, let me answer it, not with regard to any particular case, but just if in general, if past systemic errors in old systems are uncovered, there needs to be a reckoning for those errors to make whole any debtors who were harmed and to vindicate the integrity of the bankruptcy system. But relief beyond addressing direct debtor harm would be less likely or less severe if steps had already been taken to cure the systemic deficiency. So in sum, fixing a problem for the future isn't a safe harbor, but it certainly lessens the severity of the remedy.
Okay, we have a couple more. How long do you think it will take Congress to act in light of Siegel v. Fitzgerald to bring Alabama and North Carolina into the U.S. trustee system?
Well, I guess since I'm the congressional person, I'll talk first, and then Cliff, you can jump in.
Mm-hmm.
I don't know the answer to that. Let me just say that the bifurcation between the U.S. trustee program in North Carolina and Alabama is very odd and really is not defensible in any rational, logical way. However, I can tell you as a former congressional staffer, the senators and the congressmen from North Carolina and Alabama feel very strongly that they like the current system. So what needs to happen in Congress is there has to be a recognition on the part of the congressional delegations from North Carolina and from Alabama that they really just have got to surrender what they consider to be their local autonomy over the bankruptcy process. And that will take, I think, some time because there are other ways to sort of address some of the problems that were addressed in the Siegel case. I think maybe Cliff can speak to that more generally. But, when you give Congress the choice between doing something the easy way and the hard way, almost always they default to the easy way. And the easy way is not to have a fight with the North Carolina and Alabama senators.
And beyond the congressional action, I just point out, it's also possible for the federal judiciary on its own to decide to terminate the opt-outs for North Carolina and Alabama. That doesn't require any congressional action at all. And in fact, some of the judiciary and other stakeholders have in the past expressed to me some frustration with the dual system. In the past, I avoided advocating for a change because I know it would entail a very heavy management lift by the U.S. trustee program that could distract from other initiatives. So, but there have been these sentiments expressed in the past. Now, the pressure to merge the systems would increase if parties mount court challenges to the dual system, as was done with regard to the fees, because if there is a lot of litigation and it begins to bog down the system, that would naturally increase pressure to reach some resolution to take away the litigation map.
Okay, and how does credit card debt play into bankruptcy filing rates?
Well, John, I can start with that. You can fill in because John and I have talked about some data that has come out from third-party sources. I mean, as I say, the recent data show that after a plummeting of credit card and other debt in calendar year 2020, when actually the net worth of most households was going up, which many of us, or at least I wasn't smart enough to figure out at the beginning of the pandemic. So after debt plummeted in calendar year 20, now we're seeing credit card debt increasing above pre-pandemic levels, and many of you on this call have much I have seen probably. So that's often a good indicator of future bankruptcies. Now, I talked before correctly about a recession and macroeconomic conditions portending future bankruptcy filings, but it's also important to note that prior to 2008 and 9, prior to the Great Recession and the events leading up to it, bankruptcy filings had trended upward during good economic times. And why? One of the factors clearly was consumer credit was plentiful, and therefore opportunities to get into trouble increased. So right now, what do we have? We have bad economic warning signs. The externalities are not positive. In addition to a ramp up in consumer credit that had been paid down when the economy was awash in the government assistance that's now going away. So I'm not an economist, but Jamie Dimon's economic hurricane could well be approaching, and with it, an acceleration in bankruptcy filings.
The only thing I can add, because I'm not an economist or economist adjacent. What I can say is that, I mean, if you think about it intuitively, you don't file bankruptcy unless you have debt that you're looking to offload. So when debt levels were decreasing, the need for bankruptcy was decreasing. Debt levels are going up. And just one other factor I would just call to your attention, again, your forecasters and economic modeling people know this better than me, I'm sure. But when I worked on the Hill and we were looking at the health of American consumers, the Federal Reserve typically takes a look not so much at debt as just debt as an abstract number. They look at debt servicing ratios. And so as interest rates on credit cards increase, because the interest rate environment is increasing, what I wonder out loud is whether you're going to see an increasing cost of debt service. And that in and of itself, even if no new debt were taken on, that in and of itself can portend, increasing charge-offs, increasing defaults, and then ultimately increasing bankruptcy filings.
John and Cliff, thank you very, very much for the material today. And for everybody who helped put the program together. And with that, we will conclude today's session.